Good.
Good.
Good morning, everybody. Thanks for joining our Zoom call today. We're going to be talking about the 8 common mistakes that we see in estate planning. And so we're going to go through that. I'm going to try to share my screen with you today and show you the 8 common mistakes slide that we have created. So you have that. And then we're also going to try to diagram up on our whiteboard here so you can see as I diagram some things on our whiteboard. Hopefully with technology, all that comes through and you guys can see everything and follow everything. Every time I use Zoom or technology, I cross my fingers and hold my breath and say 3 Hail Marys, hoping that it's going to actually work. And so I've got Elisa here that's doing all the tech stuff, and we're going to hopefully make this whole thing work today. But it's a pleasure to be with everybody this morning. Hope everyone's doing well. Not sure about all of you, but I got my second COVID shot, and it basically kicked my butt. The second one, the first one wasn't so bad, but the second one pretty much wiped me out. And hope all of you are staying safe and healthy and doing well. So let's get started here. I think everyone that's on our Zoom call are clients, so I'm not going to spend any time introducing myself. I know most of you, as I'm looking at the people that we've admitted in, recognize all of you, and so you're all clients, so I'm not going to spend any time going through who we are and who I am. You know who I am. So the 8 common mistakes that we often see in estate planning. What I'm going to do here is we're going to share my screen, and I'm going to have Elisa pop up my 8 common mistakes slide, this one right here. We're going to pop our music off real quick. And that way you shouldn't hear Beethoven playing in the background as I speak anymore. But here's our 8 common mistakes slide. Hopefully all of you can see this. And we're going to go through each one of these in detail and kind of show you what we mean by the 8 common mistakes that we often see. So the first thing is no protection from living probate and death probate. Some of you may have gone through probate, you know what probate is, or you've heard about it. And probate really just means court. And anytime that we have to be in court, it's expensive, it's time consuming, the court's in charge, it's public, and we want to avoid that at all costs. And all of you that are on the Zoom call today have something called a trust. And a trust is the main vehicle that we use to keep us out of this court process called probate. So what I'm going to do here for the next little bit is diagram how a trust basically works, how most of your trusts work, and one of the main things that we see happen with a trust, why it doesn't work, what would screw the trust up, what would make the trust not work. And so I'm going to diagram that. Hopefully you guys can see our diagram here. So if we go to share screen and then we go to my whiteboard, well, you probably should see my scribbles here. We're going to erase those. That was my test to see if my screen was working. That wasn't my artwork, believe it or not, but I am not a good artist.
I'm going to start with that again.
It's all right. So there we got my screen. Here we go. So hopefully all of you can see my whiteboard here. Not sure if my camera angle, you're probably getting my back of my head now, but basically what we do here with your trust is we create this instrument. It's called a revocable living trust, an RLT. It's revocable. You can change it, you can alter it, you can amend it, you can revoke the whole thing at any time. And always remember, the main reason why we create the trust is to keep us out of probate. Right? That's what we just talked about. What's called living probate and death probate. Living probate is the scenario where we're alive, but we lack capacity. We have Alzheimer's, we have dementia, we have Parkinson's, we have COVID or something like that. And so we don't have the mental capability to manage our affairs anymore. And if we are incapacitated and we own assets that are just in our name, then we have to go to court and get something called a conservatorship issued over us. And that's where the court then becomes in control and they appoint somebody to manage our affairs while we're incapacitated. Well, in order to avoid that and death probate, so when we die and we own assets, then the court gets involved to decide who's going to get our stuff and where our stuff's going to go and who's going to manage that stuff. To avoid that mess, both living probate and death probate, we have this instrument called a trust. And the number one reason why trusts fail, so this is our mistake number one. The number one reason why your trust will not work is because you don't take your stuff, what we're going to call assets, and we don't transfer that stuff or fund the trust with our assets. We leave our assets out of our trust and they're sitting over here in our name. Our house is in our name, our bank accounts in our name, our brokerage accounts in our name. And now we either become incapacitated or we die. And then that leads to probate. And we don't want to go through that because it's, once again, costly, time consuming, courts in charge, all that junk. And so the trust avoids that by making sure that all this stuff is no longer in our name. Instead, it's owned by our trust. So number one, you got to make sure, I know all of you have your trust, we created it for you many years ago, but make sure that your stuff has been transferred into the trust. That's the number one question I ask my clients when they come in and see me is, did you get your stuff transferred into your trust? You got to make sure that has happened. Otherwise, you have this very expensive empty box that's not going to work. It's not going to do anything for you. And so we got to get that stuff put in. That's all. The other reason that we want you to come in every 3 years and review things is to make sure that this has happened. In that review, we talk to you, we look at your assets, we discover things that maybe you forgot to put into the trust. So very important that when you come in and review things, we look at your assets and see if those assets have been transferred into the trust. Looks like we have someone that's waiting to get into the room here. Donna entered the waiting room, okay. Sorry, we're just making sure people get in. And then once the assets have been transferred into the trust, your trust is really broken down into different time periods, okay? So period number one is while you're alive and have mental capacity. So if you're alive and you're a single person, you're in here in the trust. And if you're married, we're just going to do another sick person and put two of you in here. And this is my spouse and me. And we have the two of you in here, and we are the trustors of the trust or the creators of the trust. That's the fancy definition of a trustor, is the creator of the trust. And then we have the trustee of the trust. That's the manager of the trust. That's who can buy things and sell things and trade things and invest things and do all the stuff that needs to happen in the trust. And then we have the beneficiary of the trust, and that's who gets to spend all the money out of the trust. So in period number one, if you're single, then you're everything. You're the trustor, you're the trustee, you're the beneficiary. And if you're married, then you and your spouse are co-trustors, co-trustees, and co-beneficiaries of your own trust. And so you can manage it and control it and do whatever you want. Always remember that the type of trust that we created is a revocable trust. You can change it, you can alter it, you can amend it, you can revoke the whole thing if you wanted to. If you didn't like it, you can revoke it if you didn't like it. And always remember, you have complete control over all the income and the principal in your trust while you're alive. You can still spend it and use it and access it for whatever you want. And by doing that two things, creating the trust, drafting it, and then taking all this stuff, your house and all that junk that you've accumulated over your lifetime, I shouldn't say junk, all the stuff you've worked your whole life to accumulate, you've transferred it into your trust, we avoid probate. It's as simple as that. So 8 common mistakes, no protection from living probate or death probate. So, how do we avoid those two things? Have the trust created, make sure all the stuff is in the trust. Whenever you come in to review your estate plan with us, we verify that that step has been done so we can make sure that we avoid probate, okay? I should have said at the beginning that if there's questions as we're going through this, simply type in your questions to the comments section, or I think that's what it's called, chat box on your Zoom link there, and we'll answer questions at the end and go through that. So feel free to do that as we're going through our presentation today. But that's protection from living probate and death probate. Number 2 on our list that we have is not keeping up with law changes or personal changes. So one of the things we commonly see when people come in is that things have changed in our lives, right? So our kids get married, our kids get divorced, we accumulate new assets, we inherit assets, we change assets, our kids go through difficult circumstances, and maybe we bail them out of those situations and circumstances. We give them more of an inheritance while they're alive, and now we need to decrease their share upon death. So all of these things are changes that occur, and if those things do occur, we might need to change your trust to update it for those changes. One of the things that we often see also is beneficiary changes, okay? So before you create your trust, there are certain assets that have beneficiary designations on them by the simple nature of the type of asset we're talking about. What are those assets that have beneficiary designations on them? Those are life insurance policies, annuities, and retirement accounts. Okay, so those three types of assets, life insurance, annuities, and retirement accounts, all have beneficiary designations that go with those. Very important that you look at those beneficiary designations and who you've listed as the beneficiaries on those. Now, how should those different types of assets be set up if we have a trust in place? So once again, looking at who's on our Zoom call today, recognizing most of you on the call, you have a trust. So if we have a trust in place and we have a life insurance policy, and let's say I'm single, let's say I'm not married, I'm a single person. And so we erase one stick person here in our trust, and then I'm a single guy, and I have a life insurance policy on my life for $1 million. Well, who do I want that $1 million policy to pay to when I die? Who should be the beneficiary? Well, there's options, right? I could list my, let's say I had kids. I could list my kids. I could list my favorite charity as the beneficiary. I could list my brother, my sister, my aunt, my uncle, whoever I want to as the beneficiary. But what's the best option as far as beneficiary goes? Well, if it's $1 million policy and my trust is set up how I want it to be set up, meaning when I die, I've structured it to say where everything goes, then I want that life insurance policy to pay to my trust. I want the primary beneficiary to be my trust. If I'm a single person, pay it to my trust. And now when I die, then the life insurance will pay to my trustee, my backup trustee who I've listed in my trust. And then $1 million comes into my trust and then gets distributed out of my trust pursuant to the terms of my trust. Let's say that I'm married. How would it work if I'm married? So there's two of us. Well, once again, who could the beneficiary be? Well, most of us are going to say it's your spouse. Make your spouse the primary beneficiary. Well, once again, you could do that, but the better option is still to make the trust the primary beneficiary on the life insurance. So why? Well, because if I die, I'm the insured, I die. Well, the policy still pays to the trust. And who's the beneficiary of the trust? My wife is. So she still gets the $1 million. It's just that she's getting it in the form of a trust, which will offer more protection around it. The other thing with life insurance is the ownership. So we have a beneficiary of life insurance and we have owners of life insurance. Who could the owner of the life insurance be? Well, the owner could be me. I could own the policy, or it could be somebody else. But typically, we want the owner who have a trust to be the trust. So the owner of the life insurance would be the trust, and the primary beneficiary would be the trust. The only time we wouldn't have the owner be the trust on the life insurance is if it's a group life insurance. So if my employer has the insurance on my life, then my employer is the owner of that policy, and I can't change that to my trust. The employer will always be the owner. But any other type of life insurance, we typically want the owner to be the trust and the primary beneficiary. Question that could come up is why? Why would we want the owner to be the trust? Why not have the owner be you? Number one reason is sometimes life insurance has what's called cash value stuck inside of it. And that cash value is kind of like a checking account. You have access to it. You can pull from it. You can use it for certain things if you need to. Well, let's say I am the owner of my $1 million life insurance policy that has $500,000 of cash value sitting in it. And I'm driving home from work one day and I get in a car accident and I don't die, but I become incapacitated. I'm sitting in a hospital bed in a coma. And my wife wants to access the cash value, the $500,000 of cash value sitting in that life insurance policy to pay for medical bills or maybe pay for expenses because I'm not working or whatever. She needs that cash. Well, she calls up New York Life and she says, New York Life, hi, my name is Kimber. I need access to the $500,000 of cash sitting in the life insurance policy. And they say, well, you're not the owner of this policy. Dave Eastman is. Where's Dave Eastman? Well, Dave's my husband. He was in a car accident. He's in a coma sitting in the hospital right now. He can't talk to you. New York Life is going to say, well, I'm sorry to hear that, Mrs. Eastman, but you cannot access the cash value. You're not the owner. Only the owner can access the cash value, which then pushes my wife into a probate situation. So instead, if we had made the owner the trust, and she is a co-trustee of our trust, now in that situation, she calls New York Life. New York Life pulls up the records. Oh, yes, Mrs. Eastman, the owner is the trust. You are a trustee of the trust. You can access the cash value sitting inside the life insurance. So that is why we want the owner and the beneficiary to be our trust. So make sure one of the things you can do in these 8 common mistakes, number 2, is just verify who is the owner and who is the beneficiary of my life insurance. Call up your life insurance company tomorrow, tonight, this afternoon, whenever. Ask them those questions and they'll tell you. And then what you should do is ask them for a letter or something in writing that tells you that that's the case. And then you take that written letter or email or whatever, and you print it out and you stick it in your trust binder so that 5 years from now, when you're coming in to see me to review things, and I'm going to ask you, who's the owner and beneficiary of that $1 million life insurance? You're going to say, oh, I know I talked about that with my insurance agent when you gave that awesome Zoom seminar, but I forget who I did. And then we can open up your binder, we can look and we'll see confirmation of that sitting in your book. And that also helps your successor trustee when you die. So when you're dead and the successor trustee, your kid, your son, your daughter, your wife, whoever is sitting in my office, and I'm saying, okay, we got to figure out who the owner and beneficiary of that life insurance is. We can open up your book. We'll see confirmation from New York Life saying this is the owner and this is the beneficiary, it's the trust. Now it's easy cheesy. We just send them a death certificate and we get the death benefit. So that's life insurance. Hopefully that makes sense. If there's questions on that, just put it in the chat box. Next is we have annuities. So annuities are kind of weird. They're all contract driven, and there's different kinds of annuities. You have what's called qualified annuities and non-qualified annuities. And really the difference between the two is just whether they're going to be taxed upon death or not. And so you have to be kind of careful with these annuities. You want to know what kind of annuity is. You certainly should know, is it qualified? Is it non-qualified? With an annuities, there's 3 parties that make up an annuity. So you have the annuitant, which is like life insurance. With life insurance, you have the owner. Well, the annuitant is just the fancy legal word they use for an annuity that says this is the owner of the annuity. That's the annuitant. Typically, the annuitant is going to be you on an annuity. And that's because of the weird tax issues that you have with annuities that you don't have with life insurance. Life insurance doesn't have any weird tax issues with it, but annuities and retirement accounts do. And so that's why these are different than life insurance. So with annuities, we typically want the annuitant or owner to be you, the individual. And then with an annuity, so that's your first party that makes up an annuity. Second party that makes up your annuity is the beneficiaries. You have primary and you have secondary. And so who should the primary beneficiary of my annuity be? Well, if I'm married, then I want the primary beneficiary of my annuity should be my spouse. Once again, that's because of taxes. It's because we don't want to screw up any tax issues on an annuity. And the best way to preserve those tax issues, make sure we don't incur them, is to make sure our spouse is the primary beneficiary on the annuity. So when I die, the annuity pays to my wife, and hopefully then she can defer the taxes for as long as possible. And then the third party is the contingent beneficiary. So we have the annuitant, we have primary beneficiary, and contingent beneficiary, three people that make up your annuity. The contingent beneficiary of your annuity, if you're married, would then be the trust. Okay, so that's how the trust would play into your annuity. It would be the backup beneficiary is all. It's just the contingent beneficiary. Primary beneficiary and the annuitant are both dead, then the annuity pays to my trust. And then my trustee distributes it according to the terms of the trust. So that's my annuity. Now, if I'm single, so if you're on the call and you're a single person, you're saying, well, Dave, if I'm single, who should the primary beneficiary of my annuity be if I'm single? Well, then we want the primary beneficiary to be your trust if you're single, because you don't have a spouse to leave it to. So now it would go directly to the trust upon your death. So that's how it works for a single person. So that's kind of the basics of an annuity. Once again, if you don't know any of this information, if you're like scratching your head right now thinking, I know I have this $1 million annuity with AIG, but I don't remember who I listed as the beneficiaries, now's a good time to call up AIG or whoever you have your annuity with and say, hey, I was just reminded by my great estate planning attorney, I need to call you guys and I need to discuss who my beneficiaries are. And please tell me who that is. And they'll tell you over the phone, your primary beneficiary is your spouse. Your secondary beneficiary is your trust or your kids. And then if it's not set up how it should be, then you want to tell them you want to change a beneficiary form, and they'll send you that. You have to fill that out to get that corrected. And then once it's set up how it's supposed to be, annuitant you, primary beneficiary spouse, contingent beneficiary trust if you're married. If you're single, annuitant you, primary beneficiary the trust. Once it's set up that way, you want written confirmation back from them saying they've done that. And then you take that written confirmation, stick it inside your estate planning binder so that once again, when you become incapacitated or die, and we're going through everything, trying to figure out what you have, boom, right there in the book, we have the confirmation from the company saying this is how the annuity is set up. Now it's easy to take care of. So hopefully that helps you out on annuities. The third type of asset that will have beneficiaries with it is retirement accounts. And there's different types of retirement accounts. So we have Roth IRAs, we have traditional IRAs, we have 401ks, we have 403bs, 457s. These are all types of retirement accounts. A lot of times people get confused when I talk about retirement accounts and they think pension. Well, that's not a retirement account. A pension is an income stream. It's not really an asset. So let's say I retired from Caterpillar 30 years ago and I'm getting a pension from Caterpillar. Well, when I die, more likely than not, the pension ends. Or it may have been set up when I retired that my wife gets a portion of that pension or something like that. But when she dies, the pension ends. So pensions don't continue on 99% of the time after death occurs. So it's not an asset, meaning we can't pass it on to the next generation. It's simply an income stream that we get while we're alive, or maybe while me and my wife are alive. But once death occurs, then it goes away. So we're not talking about pensions. We're talking about retirement accounts like IRAs, 401ks, stuff like that. So with retirement accounts, what you want to do is you want to verify who the beneficiaries are. So just like with an annuity, retirement accounts are made up of three parties. You have the owner, you have the primary beneficiary, and you have the contingent beneficiary. So who should the owner of my retirement account be? Who should own my IRA? Who should own my Roth IRA? Who should own my 401k? Who should own my 403b? I should. I am always the owner of, that was my feeble attempt at a stick person. Let's redo that. I can do better. It's a little better. It's better, right, Elisa?
Much better.
Much better. Give me some eyeballs, smiley face. So I should always be the owner of my retirement accounts. The trust is never, ever, under any circumstances, the trust, the owner of my retirement account. There's never going to be a situation where that would occur. And the reason why is because retirement accounts, unless it's a Roth IRA, and when I say that, I want to be clear. I'm not saying your Roth IRA should be owned by your trust. What I'm saying is that traditional IRAs have something called a required minimum distribution. Roth IRAs don't have required minimum distributions. You paid the income tax already on those ahead of time, so you don't have these same R&D issues that you have with traditional IRAs. But a Roth IRA should still be owned by you, just like your traditional IRAs should be owned by you, okay? And the reason why is because of the R&D issue, okay? So real basically, how do R&Ds work? And so you kind of understand that. So how do they calculate your R&D? Remember, your R&D stands for required minimum distribution you have to take every year. And how they calculate this R&D is a simple math problem. They take the value of your IRA as of December 31st of the year prior. So let's say I look back to December 31st of 2020, and the value of my IRA was $1 million. And then they divide that by your life expectancy. And so the IRS has these life expectancy tables, and we can look at those tables and they'll say, hey, for a 72-year-old male, your life expectancy is 10 years. So they divide this by your life expectancy number, and that is your R&D that you have to take every year, okay? So if we don't have this number here, if I take this number away from you, can you figure out this problem? Can you figure out what this is supposed to be? And hopefully your answer is no. I know it's early in the morning and math is never fun, but this should be an easy math problem. If I don't give you this here, the divisor, then you don't know what this is. And if you can't calculate this, guess what happens to the IRS's brain when they try to figure out what you should be taking? It explodes. They can't figure it out. And so then what they do is they say, well, if there's no life expectancy to calculate the R&D, then we're going to make you take out the whole thing, which is all then subject to income tax, which is bad. That's bad planning. Well, why are you saying we'll take away the divisor? Well, because if you make the trust the owner, a trust doesn't have a life expectancy. Trust lives forever. Well, Arizona's 500 years, but there's no life expectancy with a trust. And so now there is no life expectancy number. There's no divisor. So now we have a problem calculating the R&D. So that's why we never have the owner of a retirement account be your trust. Ever, never. So the owner is always you. Next part we have with retirement account is the primary beneficiary. Who should the primary beneficiary of our retirement account be? Well, if I'm married, it's our first marriage, been married for 45, 50, 65 years. Primary beneficiary is going to be my spouse. This is Kimber. Give her some nice hair. So it'll be my spouse. And the reason why we want my spouse as the primary is for tax reasons, because my spouse gets to do something that nobody else gets to do with my retirement account when I die. She gets to roll over my retirement account to her, which means my retirement account becomes her retirement account, which means all those wonderful tax deferral things that go with retirement accounts, she gets to continue that on. So that's great, right? Anytime we can defer taxes and push that back, it's always a good thing. So that's why we want, if we're married, right? If we're married, primary beneficiary is typically your spouse. Now, there are circumstances when this is your third or fourth or fifth marriage. We got kids from previous marriages, and we don't want our spouse to be the primary beneficiary. Fine, come in, let's talk about it. Let's talk about what your options are there. But for most of us, our primary beneficiary is going to be our spouse for the tax benefits when I die. So owner, me, primary beneficiary, my wife. Secondary beneficiary, if I'm married, would then could potentially then be our trust. Okay. And we're going to talk a little bit more about that, but that's how it should work if I'm married. Now, if I'm single, I'm the owner of my IRA. Primary beneficiary could now be my trust because I don't have a wife or a husband. I'm single. So now I'd want it to potentially pay to my trust as the primary beneficiary when I die. The only time when we probably wouldn't want it to pay to the trust, either as a contingent beneficiary if I'm married or primary beneficiary if I'm single, is if within my trust, let's say I have no children, I have no loved ones, and I'm leaving everything to charity, right? Then I would want the beneficiary, if I'm single, primary, if I'm married, my contingent beneficiary, to be the charity. And the reason why is because if you pass the retirement account, let's say I have $1 million IRA and my wife and I die in a car accident, and that IRA pays to my trust, and then my trust says, give everything to Sun Health Foundation, okay, charity. Then what will happen is the IRA will pay to the trust will pay income tax on the IRA, and then it will distribute it to Sun Health Foundation. And now we've got to get the IRS to allow us to get a charitable deduction out of the trust for the distribution. And that's very hard to do. So instead, we just bypass that whole issue, have the IRA paid directly to Sun Health Foundation or Habitat for Humanity or whoever your favorite charity is, Arizona Animal Welfare League, SPCA, whatever. Then if the IRA, when me and my wife die, pays directly to the charity, now there's no income tax issue because charities don't pay income tax. So we pay zero income tax on that $1 million. 100% of it will go to the charity without paying $1 of income tax. And unless the IRS is your favorite charity, then we don't want the IRS to get a portion of that. We want the 100% of it to go to our favorite philanthropic choice. So that would be the better way to do that. Oftentimes clients will come in and they say, well, Dave, I'm going to erase some of this. Just trying to get a bit of a mess here. I know it's pretty artwork, but I have to get rid of some of this here so I can show you. But some clients with their trust, they have it set up so that when the two, oh great.
Oh, we just stopped sharing. You want to go back to your whiteboard?
Here, we have to open it. Sorry, we're having some technical difficulties with our whiteboard. We're going to open it back up.
So you were.
I didn't like the fact that I erased my beautiful artwork.
Oh man, hang on.
I think it's just having a tough time opening up. Is that it? Almost save. See if we can get this back up for everybody. If not, then you just have to hear me explain it, which isn't as fun. Is it there? Okay, hopefully it came back up for it. It did erase my beautiful trust, but we'll get it back up here. Okay, let's do blue this time. So once again, we have our trust, our irrevocable living trust. We have our couple in here as the trustors, the trustees, and the beneficiaries during period number 1. And we talked about the life insurance and the annuities and the retirement accounts and how those should be set up. And then we were talking about the beneficiary of a retirement account if we have charities involved. So sometimes our clients, they come in, they say, hey, Dave, when we both die, then we want our trust to be divided as such. Let's say we have 5 places we want our trust to go. Okay. And let's say we have 4 kids and we have a charity that we want all of our stuff to go to when we both die. This is our, our church, our, the animal shelter, whatever. And then we have our 4 children that we love equally. And so when we both die, this is how we want our estate to go. Well, the question that should be asked is how much of your estate, your trust, will go to your charity when you both die. And let's say they say 10%, okay? So let's say we have, whatever, let's say it's $1 million estate, and 10% of $1 million is 100,000, I think. Still early, but I think that's right. So we want 100,000 or 10% of our $1 million estate to go to our charity, and then the remaining 900,000 to be split between our kids equally. Well, instead of, and let's say that we have a $300,000 IRA. This is our IRA that makes up a portion of that million, right? So we have 300,000 of the million that's IRA money, and the remaining 700,000 of the million is our house and car and checking and savings and brokerage and some stocks and whatever. Well, instead of listing the charity as a 10% beneficiary in the trust, the better thing to do would be to make the charity a direct beneficiary of the IRA for the same reason. Because now, if I list on my IRA beneficiary form that I want $100,000 of my IRA to go to my charity, then once again, when my wife and I die, and this IRA is going to be paid out, I can make it so that 100,000 of the IRA goes directly to my charity. I'm going to try to erase something here and hopefully it doesn't screw up my beautiful artwork. So I remove the charity from my trust because I've taken care of the charity outside my trust by way of my IRA beneficiary designation. And then the remaining 200,000, right? Because 3 minus 1 is 2. That leaves 200,000 left in my IRA, 100,000 went to my charity, my wife and I died. 200,000 would then go to my trust, and then that would come down to my kids. But the 100,000 would come out, subtract that, that would come out directly to the charity, and there's no income tax on that. Super, super cool way to leave something behind for a charity and have the IRS get not 1 cent of that. So if you have charities that are in your trust, that might be a better way to do that is pass it to them outside of the trust directly on your retirement account beneficiary designation. So hopefully that answered some questions on beneficiary designations. The main thing to take away from this is you want to know who the beneficiaries are on everything. You want to know who the beneficiaries are on your life insurance, your annuities, your retirement accounts. You should have all that stuff inside your binder, confirming how it's set up so that when death occurs, we know how that is already all set up. Any questions on that stuff? Just once again, type it in the chat box. Do we have a chat box?
Mm-hmm. You want to see it?
I don't even know if anybody's put something in. Okay, so let's talk about a couple of these. Please describe the procedures for placing assets into the trust. Okay, good question. So, Chris, this is how we put assets into our trust. I'm going to erase some of our artwork here again. How do we put assets into our trust? What's the process of doing that? Well, let's use a couple of examples. So let's say I have a house. Probably looks more like a church, but it is a house. And the house, before I create my trust, or maybe even after I created my trust, I bought the house in my name. So this home is right now owned by Dave Eastman. Well, I don't want it owned by Dave Eastman. Why? Well, because if I become incapacitated or die, then the house has to go through what? Probate. Bad news. So how do we get a house put into your trust? We have to do a deed to transfer it into your trust. So real estate, how do we get that into the trust? We do deeds. And we record the deeds with the county. We transfer the house into the trust. That's how we would do real estate. How about your checking account? How do we get your checking account put into your trust? Well, we go into Wells Fargo or B of A or Chase, and we sit down with them and we say, when I say we, I mean you, the trustee of your trust, after it's been created. And we give you legal documents to do this. We give you something called a letter of instruction to the bank, and we give you a certificate of trust, which is a summary of your trust. But you go into Wells Fargo or Chase or whoever, and you say, hey, my estate planning attorney told me I need to get my account transferred into my trust. And then they'll do the paperwork to retitle that account into your trust. And I know what you're all saying. You're saying, wait, Dave, you just said checking account. I know you've told us not to put our checking account in the trust. It's really not true. I didn't say that. But if we have a large checking account, let's say we have $50,000, $60,000 sitting in our checking account for whatever crazy reason, then we would want that to be in your trust. If all of us are like most of us are, doesn't make any sense. If most of us are like I am, then we don't keep a ton of money in our checking account. We keep enough in there to pay the bills, and then we stock more money in it when we need it to pay the bills. And so in those cases, I've said, don't worry about the checking account. You can leave that outside your trust, because the main reason is if we put our checking account into the trust, more likely than not, the bank's going to give us a new account number when we retitle to the trust. If they give us a new account number, all of our automatic withdrawals and deposits have to be reset up. It's a pain in the butt. So we've typically said if we don't keep a lot in here, I would say if we have $15,000 or less in our checking, don't worry about it and keep it outside your trust. But if it's already in your trust, great. It doesn't hurt you to have it in your trust. You've already set up your automatic withdrawals and deposits that way, so you're fine. How about our savings account? Same thing. We'd go into the bank, tell Wells Fargo to retitle our savings account to the trust. They'll do that. How about our brokerage account? Well, we'll contact our broker, our financial advisor, and say, hey, I've created a trust. I need this account to be retitled out of my name into the name of my trust. And they'll prepare the paperwork, and you have to sign their stuff, and then they'll transfer ownership into your trust. Same thing with money market accounts, CDs. We talked about life insurance. We talked about annuities. We talked about retirement accounts. Those are all your major assets, but you have to go into your banks and financial institutions, and you have to tell them to retitle these out of your name into the trust name, and then that's how we do that. Hopefully that answered your question, Chris, on the procedures for placing assets into the trust. The main thing is, most of my clients are good about making sure this stuff has gotten into the trust. Where we slip up a little bit is staying on top of it. So as things change over time, we acquire new things, we get rid of things. We fail to stay on top of that and keep putting stuff into the trust as time goes on. And then the other thing that I see a lot is we don't keep good records of what has happened. So you come in for your 3-year review, we're looking at your estate plan, and I'm asking you the question, did you get everything put in your trust? And you're looking at me like, I think I did. I don't remember. And then I say, where's the deed to your house? Do you have it? I don't know where that is. I was never given the deed. Yeah, you were given the deed. We all have a deed. So just have good records. Have your bank statements in your trust. Have your brokerage account statements in your trust, or at least the most recent one in there, so that when I ask you the question, you can be like, I don't know the answer, but I know I put my statement in my trust. So let's look there, Dave, and you can tell me if it's in my trust. So just keep good records of everything, and then we can see if it's in the trust or not when you come in for the review. Hopefully that helped with that question. We have a question here by Coralie on IRA. If husband has dementia and unable to make decisions, can beneficiary be trust and skip husband? Okay, it's a good question. So I'm gonna give let's put this into real life fact pattern here and see if I understand it poorly. So let's say, in my hypothetical, let's say I'm married. I am married, so it's not really hypothetical, it's true. This is Dave, this is my wife, Kimber. And let's say Kimber has a $500,000 IRA. Okay, this is Kimber's IRA. It's Kimber here, her IRA. And I just said, typically we want the primary beneficiary, which would be me, to receive this $500,000 IRA when Kimber dies. But in this fact pattern, I have dementia. This little scribbly line across my head means I'm incapacitated, okay? So I have dementia. And Kimber's saying, well, if I die, I don't want this to pay to my husband, Dave, because he's incapacitated. He's not going to be able to manage this or control it. So, so can I bypass my husband, Dave, and instead just have this paid directly to my trust instead of it having to pay to Dave? And the answer to that is yes, you can do that, and this would be a good reason to do that, to bypass the spouse because they have dementia or Alzheimer's or something, and have it paid to the trust. The issue that you have with that is making sure that the trust is set up and drafted right, so that when, in my scenario, when Kimber, my wife, dies, and I'm still alive, so I'm still in here as the beneficiary of the trust, because I'm incapacitated, I can't be the trustee. So let's say our daughter, Tyler, is the successor trustee. So Kimber's died, I'm alive, but I lack capacity, so our daughter is the trustee. And this IRA then skips me, doesn't pay to me, skips me and goes to our trust. So the IRA pays, this $500,000 IRA pays to our trust. And I'm alive, I'm the beneficiary of our trust. Well, then my daughter, Tyler, needs to be able to use that $500,000 for my benefit, right? So my wife doesn't want to disinherit me. She just doesn't want me to be able to manage it because I can't. So she leaves the $500,000 in trust for me, with my daughter managing that money for my benefit because I'm incapacitated. We just have to make sure that the trust is drafted properly so that we don't cause some other tax issues that this fact pattern or scenario could cause. I don't want to go too deep into this, and certainly, Corley, you can come in and sit down, we can talk about it. But there's two different types of trust that can be drafted. There's what's called a conduit trust and an accumulation trust. Conduit and accumulation. Those are the two different trusts that can be drafted, conduit and accumulation. And this 100% has to do with retirement accounts and how retirement accounts are dealt with inside of a trust, if it's a conduit versus an accumulation trust. And we just need to make sure that we have the right type of trust drafted in that scenario that you've laid out, so that if you die, or in my scenario, I die, or Kimber, my wife, dies, and the IRA pays to our trust, that we don't get hit with a bunch of taxes that maybe we don't want to be hit with. So some things to think about, but great questions. Thank you for submitting those, Chris and Corley. So going back to our list here, we have about 10 minutes. I'm going to blow through a couple of these real quick. There's really no artwork I can draw for you. I know you're going to be real sad about that, but on these next couple, they're pretty quick. So no protection from nursing home costs. The number one expense for the elderly today is long-term care. It's going to run us right now in Maricopa County on average about $8,000 a month to pay for a skilled nursing home. And so the question becomes, how do we pay for that? Well, there's only really three options for you. That's it. You're going to privately pay, which means you've stockpiled enough money away. You know, if I have a $5 million estate, I got more than enough money to pay for my long-term care costs. So that's privately paying. Second way you're going to pay for it is you have insurance. So long-term care insurance. If you don't already have it and you're 75 years old, you're probably not going to be able to afford it. But if you've got a policy that you've had for 30 years, keep it. It's awesome. It's great. You might want to have it reviewed. Just make sure that it's maybe got some inflation clauses built into it. You understand how it works. How much is it going to pay out per day? You probably won't have a good understanding of that. But long-term care insurance would be the second way. And then your third option is you're going to hope and pray that there's some type of government benefit that's going to help cover the cost of long-term care insurance. Right now, that's called Medicaid, not Medicare, but Medicaid. And that's the federal government's, basically, it's their long-term care plan for us that are indigent. We can't afford to pay for it. And then every state adopts their own form of Medicaid. Arizona, we call it All-Tex, Arizona's long-term care system. And that's just Arizona's form of Medicaid. And all these government programs, Medicaid, there's also VA benefits if you're a veteran that you might be able to apply for. But all these benefits are means tested, which means they're going to look at your assets, they're going to look at your income, and they're going to look at your health to decide if you'll qualify for these benefits. And if we have too many assets, if we have too much income, we won't qualify for these government benefits. So then you're kicked back to those other two ways. You're going to have insurance or you're going to privately pay until you have nothing left. And then Medicaid will kick in and pay for the long-term care cost. You have to realize that where we're going in America, there's 10,000 baby boomers turning 65 every single day. Not every week, not every month, not every year, every day. 10,000 people are turning 65 in the United States. That's going to happen for the next 15 years, 15 to 20 years. So there's going to be this huge weight put on our medical system. So Medicare, Medicaid, they're going to become stressed to the max. And so if you think $8,000 a month now is expensive, just wait 5 years from now, 10 years from now, 15 years from now, it's going to become outrageous. And the sad thing is I guess I shouldn't say it's sad. It is sad. We're living longer, but we haven't found cures for things that put us in nursing homes, skilled nursing homes. We haven't found cures for Alzheimer's or dementia or Parkinson's, these types of things where we are going to need 24-hour care, and that's where the cost it kills us. And so, don't want to be the negative person here, but that's kind of what you have to look forward to as far as long-term care goes. So that's our number 3 item on there. No provisions for minimizing taxes. I just want to talk about a couple of things in that regard. We may not make it through our whole list today, but I'm sure you're not going to be disappointed if I don't sit here and talk to you for another 2 hours about these things. But let's talk about taxes for just a second. Can I get my whiteboard? Sorry.
No, sorry.
You worked so hard to get me out of my whiteboard, and then I want to go right back.
Maybe share the screen again. I can't see.
So hopefully you can see my whiteboard here. And we're going to talk just real quick about taxes and some things you should keep your eye on. We talked about this, I think a month ago, maybe 2 months ago, but it's always good to repeat. So when we talk about taxes, there's a couple of taxes that you need to be aware of. The first one is your federal estate tax, okay? So there's also state estate tax, okay? So there's federal estate tax and there's state estate tax, okay? Just like income tax, right? We pay 2 different types of income tax every single year. Some of you just paid your estimated tax for 2021. But just like income tax, we have estate tax. That's a death tax, okay? So you thought you paid enough taxes while you're alive. Well, guess what? When you die, if you have too many assets, then you're going to pay a death tax as well. So let's talk about the easy one first. State estate taxes. Arizona, just so you know, does not have a state estate tax. So Arizona is still a great place to live and die. There's no state estate tax in Arizona. That's not the case for all states. Okay, so as an example, Oregon has a state estate tax exemption amount of $1 million. In Washington State's state estate tax exemption is $2 million. I think Massachusetts is $1 million. So you have states that do have this state estate tax, and the exemption is very low. Right? And you're saying, well, why do I care that Oregon has $1 million state estate tax? Well, because if you become incapacitated and your son Johnny, who lives in Portland, moves you to Portland so he can watch over you and take care of you and do whatever, well, now you are a resident of Oregon. And now guess what? When you die, every dollar you have over $1 million, you're going to pay 16% of that to the state of Oregon. So you need to be aware of it. You need to understand that there are state estate taxes that you might be subject to because you might not be when you die, a resident of Arizona that currently does not have a estate tax. How about federal estate tax? Well, this is always a moving target, okay? This started out in the late 90s at a $600,000 exemption amount. And then in 2001, when President Bush passed into law EGTERRA, the Economic Growth Tax Reconciliation Relief Act, he increased it. And then every year, since 2001, it was creeping up and creeping up. And then in 2010, it went away because it sunset and Congress didn't put anything in place. And so if you were George Steinbrenner and you died in 2010, your kids saved billions of dollars in taxes. And then Obama put it back in place, and his exemption was $5 million indexed for inflation. And then President Trump in 2017 changed the tax again, and he increased it to double Obama's exemption. And so in 2021, as of right now, we are each as American citizens entitled to die with $11.7 million per person without being subject to a federal estate tax. So that's a lot of money. Less than, I think, 0.5%, maybe even less than that, are going to have to worry about paying a federal estate tax with an exemption that high. But this, more likely than not, is going to change. Okay, Biden's platform that he ran on, and what we all thought he was going to do with his latest proposals, was to drop this exemption to 3.5. Okay, so that's a pretty significant drop from 11.7 to 3.5 per person. So you want to keep your eye on that. You want to, make sure you're understanding how that's going to affect your estate if they end up dropping that exemption to a $3.5 million exemption. There are situations, and I did this last year with a couple of clients of mine, where we took advantage of this 11.7, because if it goes away, you lose it, right? You're going to either use it or you're going to lose it. So if they drop it to 3.5, you've just lost out on a huge tax advantage you could have taken advantage of while we had the 11.7. So if you have a significant estate, if your estate is 20, 30, $40 million, something like that, then you might want to think about gifting a chunk of your estate out now while you have 11.7 that you can use. So those are some things to keep your eye on. The other thing that Biden has talked about when it comes to tax law changes is your cost basis adjustment. So in addition to dropping the estate tax exemption amount, he's talked about getting rid of this cost basis adjustment when death occurs and capping us at $1 million cost basis adjustment. And I think the reason why he capped it, or why at least gave us the $1 million exemption from capital gains, is for small businesses and small farms that would incur this tax when death occurs. But this would be huge. The cost basis would be huge. It's probably one of the hugest, best benefits that we get under the tax code right now. If I have a highly appreciated asset that I've owned for 30, 40 years, and let's say there's a capital gain in there of $4, $5, $6 million. It's a piece of property in Arizona that we've had forever, and bought it for $100,000. It's now worth $6 million or something crazy. If I sold that today, I would owe a capital gains tax. Well, if I wait until I die, then when my wife or my kids receive it, they'll receive it at the cost basis adjustment of $6 million. So if the cost basis is $6 million and the fair market value is $6 million, the difference between $6 million and $6 million is zero. Well, 0 times 25% capital gains tax is 0. That saves a ton of capital gain. And this is what Biden is talking about getting rid of, that you're not going to get that cost basis adjustment when death occurs anymore, or they'll cap it up to $1 million. And so those are things to just keep our eye on. If you want to know more about this stuff and maybe some tax planning strategies, you can certainly come in and see us, and we can talk about it and see if there's anything that we can do right now. But these are some of the tax law changes that might be coming down under the Biden administration to keep your eye on. So we didn't make it through everything. It's a minute till. I'm not going to keep you any longer, but we certainly can finish talking about the remaining. I think we got through half of them, which isn't bad. The remaining of those items on our next Zoom call. So once again, just a reminder, if there's any questions, you can certainly type those into the chat box. Happy to answer any more questions that people might have. Doesn't look like we have any more, so I think we're set with those. We are going to do our drawing. Elisa has put everyone's name into our little coffee mug here that's on our Zoom call. And just like last time, if you got our newsletter that Elisa puts together every month, and those are awesome. She did a great job on those. They're really good. Hopefully you're getting those. If you're not getting those, certainly email us. We'll be happy to make sure we get that sent over to you, but it's just a monthly newsletter we send out. But anyway, we've got the names of the people that have attended today, and our last winner, I think, was Karen Kolb, who won. Oh, we got a raised hand. So let's do this drawing, and then we'll do a raised hand. And then this is our gift basket that we're going to give to somebody. Somebody said me.
Oh.
All right, eyes closed, no favorites here. I'm not playing favorites, right? You can see my mug. I'm just gonna swirl these around. And we got Dan Lowry. Dan Lowry is our winner. So Dan, we will make sure we get that sent to you, or you can come in and pick it up. We'll have Elisa coordinate that with you. But congratulations on being our winner of our gift basket, and we'll get that to you. We do these every month, so hopefully you guys appreciate the content. And if nothing else, you can win a gift basket. So that's always good. So any other questions that we might have? I think that's it. So that's everything. Well, appreciate everybody. Thank you so much. Hopefully you enjoy the rest of your week, and stay safe, and we'll see you next month. Bye-bye.